What is my case about? My case is about serious issues in an intensive care unit in a reorganised trust by the Secretary of State for Health all the way back in 2013. It ran an intensive care unit at night with a doctor and patient ratio that departed dramatically from national standards. For example, the standard says 1 doctor 8. This place ran 1 doctor 18. And in addition to that, covering the emergency department and wards. And when I raised that very obvious issue, I was well supported by several other doctors. And that support started to move away, and you can probably guess why. So I was ignored raising these issues. And then months later, 2 serious incidents happened. Now that, to the uninitiated, is a chest drain. And it's simple stuff. Chest drains go into the chest and not the liver, where all the blood is. And when they go into the liver, the patient bleeds to death. And that is what happened in one of the SUIs. An inexperienced doctor put in the situation that I described, did this procedure incorrectly, were too inexperienced to realise they did it incorrectly. And then the results was the patient slowly bleeding to death through the night in an intensive care unit. And there's another serious incident, which I haven't got time to go into. But you might think they would be very important incidents. If you're going to wonder whether Dr. Chris Day is a dishonest charlatan with his evidence-based concerns, you might want the investigation not to exclude those 2 SUIs, which is what they did. So I say, as many whistleblowers say, that I had my career destroyed and I was subject to loads of detriments. I was vilified, discredited, etc., etc. The methods we've discussed, I'm not going to go over the methods in my case because we've been there. We've spent the afternoon doing that. And I'm here to talk about lawyers. So Lewisham and Greenwich and Health Education England had a whistleblowing case to fight. And they had 2 law firms and 2 barristers to do it with. And this is where my point is, how we spend the money. Now, of course, I can't say lawyers are bad, whistleblowing cases are bad, and we shouldn't have lawyers fighting for the NHS. But we do need to look at what they do in the public's name with their cash. And it wasn't get into the issues of the ICU and the patients bleeding to death, which won't surprise you. What they tried to do is undermine my work employment status as a junior doctor in order to stop the case being heard. And £500,000 was spent misleading a court in how me and 54,000 doctors were employed by objectively false submissions and hiding commissioning contracts that same law firm was paid to draft, more public money. And what is important about whistleblowing law in this country is that it's an employment law, and the first thing you have to do is prove you're employed by someone. And so effectively what the NHS did to try and deal with the serious issues in my case for 4 years was to convince an employment tribunal that no one employed me, just to stop the case being heard. Now, for the first 4 years, the legal world thought they did it with clever legal arguments, and it was all very exciting, my trip to the Court of Appeal. I will not bore you with the details. But the good old Telegraph found out it was rather more simple than that, and it was basically Hill Dickinson solicitors saying through their counsel a load of things that weren't true about the way doctors were employed and hiding large numbers of commissioning employment contracts that showed perfectly plainly that I had a long-term employer and every doctor in the country also had a long-term employer. So after 4 years and £500,000, the case finally got listed for a full trial, and that was in October 2018. Now, don't get too excited, because that didn't go to final judgment either. During my evidence, myself and my legal team were threatened for costs. And when I say threatened for costs, I see the KC in the corner and now I'm nervous. So let me be very specific for his benefit and any other lawyer in the House. I can prove 3 to 4 ordinary cost threats, a wasted cost threat, a threat to refer my legal team to their own legal regulator, and a threat to refer me to the GMC. That was the leverage used to terminate the final hearing of this case. Oh, I have to stop. Yeah. So the lawyers think, great, we've done it. We've got him to drop the case. But because the case was crowdfunded and because I think, as you say, I'm famous, I'm not sure I agree with that, but insofar as there were 5,000 people that probably knew the case, they knew that they smelt a rat. And so the first thing I was accused of was taking a massive payoff. And when it became clear that that wasn't the case, it became clear I'd been threatened in some way. And that gave them a massive, massive problem. Because they had to explain why Dr. Day, who's been fighting for 4 years in the public domain, been on ITV News at 10 and various press, would suddenly throw in the towel and make a public statement saying that, on reflection, I believe the NHS acted in good faith in the case. And this is where not lawyers don't have the answer to everything, because the lawyers would say, well, we tried to stop the case being heard, we pushed him into settlement, what's your problem? And then they go off to a different case and they leave, the carnage of a cover-up, a case that's been obstructed, and an NHS trust that has to answer all these questions, and with the Department of Health. And this is what they did. So those cost threats that I have very clear evidence of in writing from my barrister were denied. In secret briefings to the press, in secret briefings to MPs. And so Norman Lamb, an MP, decided to challenge the trust on their denial of cost threats. And this is where we were given this letter from the managing partner of Capsticks to the board of Lewisham and Greenwich, categorically denying that cost threats were used in the case. Now, I'm not going to accuse the managing partner of the biggest law firm, Wim says the best law firm in the NHS, of lying in a letter to the board. I would never do that in the Royal Society of Medicine.
But we all know what you mean.
Oh. And so these letters went out, briefing letters to MPs, to councillors, saying that he wasn't threatened for costs. And he just decided that the NHS acted in good faith. He had some reflection. And this was the sort of thing going to South London MPs and councillors. But it was more than that. Now, the lawyers will probably understand about cost threats, but for the NHS staff and patients, they also said this. They told all these people the case wasn't about the intensive care unit. It wasn't about deaths. It was actually about a one-off issue, one night on the wards that was resolved. The other thing they said was that external investigations found that the trust, the NHS, handled the situation in the right way. Now, there's just 3 things that they found against the NHS. A Datex report not being followed up or logged onto the system. Nothing dodgy about that. A bullying and harassment response from the Assistant Medical Director with a wide senior audience copied in. Apparently that's responding in the right way. And then perhaps the chestnut, an email to Health Education England saying, of my patient safety concerns, his inability to let these issues go is starting to worry me. I would consider not employing him again as a result. Now, if that isn't enough to win a whistleblowing case, I don't know what is. So this all came to court in June 2022. Basically, it came out, these false briefings to the press and MPs. Some MPs made me aware of them. And so there was a hearing in June 2022, and the dishonesty of the NHS was set out by two consultant anaesthetists and a former health minister, Sir Norman Lamb. I think I'm out of time. I think the issue, look, I'll bring this into land because I am out of time. I was getting to the good bit though. The issue here is we spend a lot of money on these cases, and I'm not saying that's bad, and I'm not saying lawyers don't need to be paid. I'm saying that they need to tell the truth, they need to not hide documents, and they know all of this stuff. And so I need to just say this actually, at this hearing when all of this was supposed to come out, Dr. Smith, this brave consultant anaesthetist, set out how dishonest the NHS response about the clinical issues was. And we put so much pressure on the Lewisham and Greenwich NHS Trust that their director that had authored these statements, these briefing statements, with capstick solicitors, got mentally unwell, he says, and went into the hospital at 5 a.m. and destroyed an archive of evidence for the case that wasn't disclosed. Now again, if that isn't enough to win a whistleblowing case, I don't know what is. And this was made clear to a packed public gallery, yet the judge decided to turn a blind eye, and I ended up, the narrative of me being the dishonest charlatan was reignited, shall we say, even in light of all of that. And there's the press coverage. You see, it didn't go unnoticed, the NHS destroying 90,000 emails during a hearing. Anyway, I don't want to depress you. I've been given the right to appeal that decision, and there might be hope for me. But I come back to the point, the way lawyers conduct themselves in these cases have consequences, patient safety consequences, and consequences to NHS staff.